So those two must be from the state. I kind of figured that she was gonna say something like that anyway. I kind of figured that she was gonna say something like that anyway.
Ma'am, we can hear you.
Oh, thing.
All right, pardon me, we did address an issue while I was on mute with regard to our YouTube live stream. The first part of our hearing was not on live stream. We are now on live stream, and we have solved the problem with regard to the loop. The issue is mine. It's not it does not have any bearing on the hearing. The issue is the judge's obligation to make meetings public, hearings public. It does not, in my view, affect Mr. Gipp's rights. It doesn't affect the state's case. It affects my job as a judge. And I will say that I thought that we were on YouTube. I thought that we were live streaming. And a really brilliant IT office came actually literally running over here to tell me that we had a problem and that she has now fixed that problem. In view of that fact, I would like to propose that we go forward. And again, the risk is mine, but I feel like in good faith, I was doing everything that I could to make sure the public was aware of what's going on in its court system. If anyone has any objection to this, I would ask them to state that now for the record. Ms. Lubinsky?
None, thank you, Your Honor.
All right. And Ms. McClure on behalf of the state?
No objection, Your Honor.
Okay. All right. I'll hear from you, Ms. Lubinsky. And if you would like for me to hear from Ms. Jones, I'm happy to do so.
And
I'd like to hear from Ms. Jones.
sorry,
I'd like to hear from Ms. Jones.
Ms. Jones, would you unmute? Ms. Jones? Can
Yes,
you?
I'm sorry. I was
We can hear you.
now what was said?
Ms. Jones, Anwan is your son. Is that correct?
Yes.
Can you tell us a little bit about his illness and how it's affected his life?
It's very serious, his illness, and it affected his life. Like, and one, it affected it affected his life. Like, he can't really do anything that he really wanted to do, as he couldn't do nothing that he wanted to do as a child, because little stuff will trigger his sickle cell and stuff. Like, he done been to the hospital like over 1,000,000 times out his childhood. He just don't need to be in there like
to get it.
ma'am.
Ms. Jones, can I ask, and I don't want to usurp you, Ms. Lubinsky, but Ms. Jones, can I ask you, what are you able to offer in terms of supervision? I mean, you know, every word I use from here on out would really be a synonym for supervision. So, you know, I could reel off a bunch of conditions, but I'm really curious as to what you could provide to assure us that, number one, if there's a curfew, he stays at the house. Number two, you know, that he's really not free to do anything other than go to medical appointments or go see his lawyer.
I can make sure that he's stay in the house. Y'all can even put a monitor on him, because I work also doing I work from 5 to 2 every day. Sometimes I might have to work a double shift because I work at the police station. So hours is very tight. But if y'all can put a monitor on him and we can monitor him like that, but I don't feel like that I wasn't gonna flee at all, because he's not that type of person to, like, I mean, he listened. Whatever he did out there, I don't know what was going on, but he's really a mountable child.
Ms.
All I can say
Jones,
right
who
now,
else is in Ms.
y'all,
Jones, who else is in the house?
he have another brother in the house as
How
well.
old is that brother?
He's 27.
Are any young children in the house?
No, ma'am.
So it would be you and the two sons.
Yes.
Okay. Anything further, Ms. Lubinsky?
Yes, thank you, Your Honor. Ms. Jones, when I spoke to you, you mentioned something about a particular kind of sickle cell that Anwan has.
He has SS.
And what does that mean?
SS is the more severe sickle in the cells. They have it's SCSS and A, but SS is the more severe sickle cell.
Thank you.
We have to have blood transfusions, a lot. He go through a lot. He don't went through a lot. Like, he can have a stroke at any time. His body get real tense. He can't walk, barely can walk and stuff. It's very severe.
Ms. Lubinsky, are you aware of any problems that I'm not, but so this isn't a loaded question, but are you aware of any problems that Mr. Gipp has had while in custody?
I haven't looked, Your Honor.
Okay.
I haven't, no.
Is the state aware of any problems Mr. Gipp has had while in custody?
Not at this time, Your Honor.
Okay. All right, I'm gonna take this under advisement, meaning I'm not gonna give you an answer right this moment. I will tell you what my concerns are. My concerns are that Mr. Gipp, I don't want to make him more frustrated. He has demonstrated a lot of frustration with our system. I get it. I'm not punishing him for that at all. This pretrial incarceration is not, and these aren't just words, it is not intended to be punishment. He has recognizably a history that is of concern, and I have seen evidence in the case that I was entitled to see. It's not like I went out on Google and tried to find out a lot about Mr. Gipp. I heard the entire police interrogation. I watched the entire body cam footage. Those are things that I'm not able to unsee or unhear. I'll be honest with you. He's presumed innocent, but I know about these things. The odd thing is that he's pretty polite. I mean, he's pretty respectful. Yes, he ran. I get that, and he was cornered. I get that what happened at the gas station, if he was involved, if he was not involved, was terrifying for the alleged victim. Believe me, I understand both sides of this, and this is not intended to be punishment before anybody has found him guilty. But his background is of great concern. I don't want to make him angrier. I don't want to make him more frustrated. And for heaven's sakes, I don't want him to be subject to a horrible medical condition being worse. Believe me. And we don't have etiquette rules that people have to get on your good side in order to get good treatment. That's not it at all. I am concerned about Mr. Gipp. I have always been concerned about Mr. Gipp, and I'm also concerned about our community. I will get an order out just as soon as I can.
Thank you, Your Honor.
Can I say something?
Yes, ma'am.
Can I correct the address, because the address I have on file, I don't stay there.
Sure. Please tell me what your address
It's
is.
2591 Etheridge Drive.
Do you mind spelling that, ma'am?
It's ETHERIDGE Drive Northwest. Apartment A is in Alex, 101, Atlanta, Georgia, 30318.
Okay. All right, great. I appreciate you doing that, Ms. Jones. I appreciate your being present this morning. Mr. Gipp, thank you very much. And again, I'll get something out just as soon as I can. I appreciate it.
Thank you, Your
Okay,
Honor.
thank you.
All right, thank you. Okay.
You have a hearing about somebody running against Joe Barnes or something today?
No.
Okay. Thank you.
Oh, all right. I'm going to mute for just one moment before we get to Galloway.
Are we finished with position one?
Yes.
Thank you. All right.
I'm struggling with this. That one.
He back in court? What's going on this time?
I'm just mad. I was getting on that late. I forgot. Yeah, it's something like racial type shit. Hopefully. Well, they're supposed to get a save today, I think.
Can the user with the iPhone please put your phone on mute? Whoever iPhone is, please put your phone on mute.
Keep them happy, Kathy. Okay. Hello, y'all. The judge had to run down to sign a piece of paper for Judge Brasher. She will be right back, and we'll get going. So who do we have next?
Position number two, Mr. Galloway.
Awesome. Okay, we'll be ready in just a minute. Hey, y'all, do we have a plea on Mr. Hurd?
Second. Kathy, you mean Mr. Jones?
I mean, Joe, yeah, sorry.
Give me a second.
Okay, no
Okay.
problem. Just curious.
Okay.
Thanks. Jenny, Kelsey's not on here, is she? Is it Kelsey who has Jackson, Deontay Jackson? You're muted, Jenny.
Have the records arrived?
They did.
Yay!
To figure out how to see them, and I think it might be
Okay.
because
So I subpoenaed the records. If the judge has finished having a look at them, has she or not?
I'm not sure. They were in my chair when I got here, and we haven't had a chance to talk about it. I just thought I'd take this time while she's gone down there to see. Are you going to be coming here anytime, or?
I can.
Yeah, I don't think she can send them. How about Friday? Because I'll be here on Friday.
Sure. Sure.
Okay, so I'm going to be here from like 8 o'clock, I'll say, until all day, because we have court at 1 o'clock for, we're filling in for Judge Brasher this week, doing the non-complex pleas. So I'll be here all day. So if you want to just, I would say text me or call me, because I don't know if I'll be like in the office every minute. I might be in the courtroom. I may be back and forth. So just let me know and you can come in here and look at them.
Thank you. That's very, very helpful.
Okay.
I never function very early.
Okay. No, I'll be here all day. I'm just saying, if you had something else planned, if you wanted to come in early, that's fine, but I will be here all day.
Okay, thank you. And I don't think I've got anything else on today. Do you need me for anything else?
No, ma'am. You don't have to sit here and wait.
All right. Then I will see you tomorrow.
Okay.
Thank
Bye.
you. Bye.
Bye, Jenny.
Bye.
I just let Jenny go. She's going to come Friday to look at those defects. Did they come? Yes, they were on my chair. I thought you had already seen them. Okay, so you'll have to look at them beforehand. I have not heard from him. Let me, you want me to, I can't do anything on this computer right now. Let me go email him and see.
Let me see if he's emailed me.
And she's gonna tell us if anybody shows up out there. The deputy is.
Okay.
Let me,
Do I have time to swear in the attorney?
yeah, when they get here, or are they down there?
They're on the Zoom.
Oh! Let me get Nick and see what we're doing.
Okay.
And Kathy, to answer your question, no, Jones is not going to be a plea today. We have a joint announcement for the judge, but it's definitely going to resolve.
Okay, go ahead and tell me the announcement. You guys, you can go. There's no reason for you to have to sit here and wait. She'll be back in a few minutes, but.
Okay, we just need like a week and a half, 2 weeks. Ms. McClure she's not as familiar with the case as Lauren and I had. Today was my first time actually having an opportunity to speak to her. I thought Lauren and I would be resolving the case, but the offer is still open, and I've communicated that offer to Mr. Jones. It's just a matter of Ms. McClure getting up to speed, as well as us discussing his psych evaluation and his mental health issues. And I did provide that psych evaluation to the judge yesterday.
Okay, so I will reset it. We have one, I think it's the 26th. It's we have just 2 people on there, but Goolsby, which has 6 cases or something, Mr. Goolsby. And we have, maybe it's Heard that is on that one, who is possibly going to be a plea, but that usually takes a little while.
Mm-hmm.
So I don't know if I'm going to be able to put it on that one. I might have to put it on the one after that. Well, you know what? I'll put it on there anyway. Just if we can't get to it, then it'll just have to be put on the next one.
Okay, and it is going to resolve in a plea. It's just getting the number together.
Yeah.
Okay. Well, I'll do that. I'll just put it on the 26th. I think it's the 26th. I don't.
Okay. And I was gonna try to go non-negotiated, but I don't want to waste the court's time, because that also takes a while to get the whole plea colloquy, and then he may say no. But we just need to get to a final number.
Okay. Is that good with you, both of y'all? I'll reset it then.
That sounds
Okay.
good.
26.
Yeah. So jail, courtroom 2. I don't know if he's there. I'm just going to tell him we don't need Mr. Jones.
No, he's not courtroom 2.
Where the deputies, we do not need Mr. Jones, just FYI. So I will put that.
Okay. What position is that?
That's number 3 and 4.
Thank you.
Okay. Let me look at my calendar. I got to go look at the freaking calendar.
Hey, for position 3 and 4, he's reset until when?
Kathy's looking at the calendar, but I think it's going to be October 26th.
Okay, thank you. So I can let him know.
Welcome.
So I was gonna do my plea dance, but it's not happening today. That's okay.
No, but you're still gonna get to do it.
I am. Janie, you can go if you want to go. I'm
Okay.
filling in for the judge at this moment, so.
Okay.
Kathy.
Well, I will see you all next week because I
Tomorrow? Oh,
don't have anybody on the calendar tomorrow.
What? Okay,
All right. Take care, everyone.
bye.
Bye.
Kathy,
Yes.
good morning. Michael Hill.
Hi.
Hey, look, are you able to put me in a breakout room with my client,
Yeah, let me try to do that.
please?
Actually, I have to do a breakout room with everybody. But you two just are the only ones who need to go in there, okay? I don't know. Let me try manually.
Is there anything that I do in particular? I've never done.
Hold on. I'm going to see if I can do it this way.
Okay.
He's in courtroom 2, and then Michael Hill, and then okay, did you get?
Okay.
You got a request?
How you gotta do that?
I got the last two are reset. They're gonna have a plea on the 26th. So we just have
A plea for Gerald Jones? Sweet.
negotiated. But they still have a couple.
What about Galloway? Did Singleton get me at him?
Oh, no, we're ready.
Oh, okay. Oh,
We're
I
still
thought
going
they,
on that.
okay. And they heard me. I was not on mute. So what I meant to say was Ms. Singleton, and not a Singleton ready. I am enthusiastic about continuing to hear more on Galloway. This is a case that I have had staring at me, hoping for more information. And so now I think we have that opportunity. So can we go on the record, please, on that case?
Yes.
Yeah, okay. So this is, Samantha, this is the state of Georgia versus Javarius Galloway. This is 19 SC 171070. Appearing today on Zoom are Mr. Galloway's lawyer, Michael Hill, and the state's attorney, Mr. Adam Petty. We all are appearing via Zoom today, including, I believe, Mr. Galloway, who is in the Rice Street facility. I suspect, Mr. Petty, that you may want to ask questions about, which we have done before, but if you would like to update the information on Mr. Galloway's waiving his right to appear personally in the courtroom and appearing instead via teleconference or via the Zoom video conference platform. I will say that we heard this matter extensively on August the 31st. I had asked for some additional information and was told at least that Ms. Singleton may in fact have additional information. But at this point, Mr. Petty, I'll turn these proceedings over to you.
Thank you, Your Honor. Mr. Galloway, good morning. This is Adam Petty from the state. Can you hear me? Can you hear me okay?
Yes, sir.
All right. Mr. Galloway, we're conducting this hearing today via the Zoom platform. You're already aware that you have the right to be physically present in the courtroom for any hearings on your cases. Do you waive the right and do you agree at this point to have this hearing via the Zoom platform?
Yes, sir.
All right. You also are represented by Mr. Michael Hill, your attorney, who's also present on this Zoom conference. You also have the right to have Mr. Hill physically present with you in the courtroom to have any hearings on your matters. Are you also okay waiving your right to have Mr. Hill physically present and have him on the Zoom conference?
Yes, sir.
All right. Thank you, Mr. Galloway. Your Honor, I have nothing further. Thank you.
All right, I'll turn this matter then over to Mr. Hill.
Good morning again, Your Honor, and to everyone else. Your Honor is correct. On August the 31st, we had the initial portion of this hearing, and I think it was adjourned at that point in time, and Your Honor had requested some additional information. It is my understanding that Ms. Singleton has procured that information. So if it pleases the court, then I would ask that Your Honor would hear from Ms. Singleton unless there's some specific information that Your Honor wanted to hear from me.
I'd love to hear from Ms. Singleton.
Good morning, Your Honor.
Good morning. How are you?
I'm good, thank you. So, Your Honor, I have spoken with a few parties concerning Mr. Galloway, 2 family members for possible consideration for living situation if the court were to grant a bond. I've spoken with his aunt, Demetrius Galloway, who is on the Zoom with us today. If the court decides to grant a bond and wishes me to provide the address, I do have her address unless the court wants that now.
I do know. Yeah, let's hold on to that for just a moment.
Okay. She is currently working from home, and so she would be able to provide 24-hour care for Javarius. She does have 3 daughters that live in the home that attend Banneker High School. She also has 2 grown sons who do come visit that are in and out, but they are 22 and 25. So I did go over with her the possible bond conditions that he would receive, including an ankle monitor and my visits pop up face to face, and she was perfectly fine with complying with those, as well as any curfew that the court would put in place. And I did explain to her that most of the cases that I supervise receive a 24-hour curfew, where they're only allowed to go to school if they're doing face-to-face school. Other than that, a few minor considerations such as haircuts and things of that nature and medical, but that he would basically be in the home at all times. And so she has stated that she is willing to provide that and would be there with him at all times. The second family members that I spoke with, Your Honor, were the grandparents, the maternal grandparents, Mr. and Mrs. Williams. Miss Williams, his grandmother, had a doctor's appointment this morning, and so I don't believe that she's on the call. However, Demetrius Galloway did state that she'd be able to call her if the court needed to speak with her. I do also have her address, Your Honor. If he were to reside at that home, there are no other people there except the grandparents. Miss Williams, his grandmother, works for the school system, and so she has Monday through Thursday hours that fluctuate slightly. However, the grandfather, Mr. Williams, is retired and would be at home at all times. They are both committed to all of the bond conditions that the court possibly would put in place, and stated that he would be welcome in their home as well. Your Honor, I then thought that I would reach out to Westlake High School. And so I spoke with the defendant's mother, and she was able to provide a phone number for Miss Vaughn, Vaughn, who I'm actually familiar with. I've dealt with and worked with her through the years on other cases that I've had that have attended Westlake. Ms. Vaughn's title at this time is a response to intervention specialist. However, she was also Javarius's 10th grade math teacher. So in the current role that she plays at the school, what she does is students that are determined to either have an academic or discipline deficits, her job is to determine what the school can do to assist them, whether it is to have them placed in special education or place additional services in the classroom, or set some type of situation up to assist them with discipline. Her time working with Javarius has been based on academics. She explained to me that she has known him since the 9th grade. However, as I stated, she was his 10th grade math teacher, that he failed quite a few classes, 10th and 11th grade. This was due to attendance. However, once he was pointed as someone that needed to be placed under the program that she's involved with, she made a determination about a plan of action that they needed to try to follow for him to get back on track. One of the issues is that he has had an IEP to assist him with school. And so in his case, his speciality has been that Javarius has a hard time processing verbal cues. So her example that she gave to me involved, if you gave him instructions verbally to do some steps, such as go upstairs to the second door on the right, take something off the 3rd shelf, his processing of that information may be hindered. You may have to repeat that several times and give him different examples of how to handle it. So he had an IEP in place where there were people put in place to try to help him with school instructions on schoolwork and things of that nature. That IEP was ended in his 9th grade year. After that, they saw the change in his ability to complete tasks at school during 10th and 11th grade, causing him to miss, he was not performing academically. He was also not attending school regularly. Once she sat down with him and set out a plan where he would do credit recovery virtually, as well as she would hands-on assist him with his in-classroom work, she said that he completely turned his entire situation around in record-breaking speed. Javarius managed to complete all failed missed classes in matters of weeks per class. And by the end of his fall semester of his senior year, had managed to become a senior and was scheduled to graduate in May, which would have been May of 2019. However, the defendant was arrested, I believe, after January of that year. But he had actually managed to successfully catch up all his failed classes virtually, and which she said is a much better setting for him because he's able to read the work that he needs to do as opposed to someone telling him what to do. And so he does much better with the reading and the processing that way. So she was very excited about the fact that he had managed to do that. And what they were actually working on was that he was to join the military after he graduated, was what the plan was in place. And then the circumstances that he finds himself in now had occurred. I did ask her if she could pull his discipline reports and let me know what type of discipline issues. And she did text me that information just this morning. She stated that he had around 3 or 4 altercations with other students over the 4 years that he was at Westlake, but the school did not view them to be of any major concern. And so he was never tribunaled out or removed from the school. He stated that he was not combative with any staff and was always described as polite and quiet. And that seems to be the description that I've received from all of the parties that I've spoken with concerning him. She did also state that if he were released on bond, she would request that he receive a new evaluation for a new IEP, which would then put services in place for him. He is allowed to continue to participate at Westlake as far as his graduation being there. She would recommend that he do all classes virtually at this point on the Fulton Virtual Academy because he had done so well with that before just doing the credit recovery. And so she thinks that he could still catch up what he had missed because he was pretty much caught up. So he only has 1 semester left and that he would still be able to graduate with his diploma from Westlake High School. But she is committed to, at this point, working with him if he is released. And she did want the court to know that as well. I believe that, oh, and Your Honor, I did, so when Javarius was arrested, he was 17. And so he did not go to Metro. I typically interview everyone that comes into Metro face-to-face or during these times via Zoom or some virtual way. I only had 1 contact with him, and that was when he came for his prelim in the back holding cell. So I was able to ask him a few questions at that time, but I've really not had an opportunity to speak with him. So during this process, I asked his mother if she could assist me with trying to speak with him at the Fulton County Jail. And she did do that. So I did have a conversation with Javarius as well before I notified the court that I had the information to provide. And at that conversation, I just asked him what did he, if he were released on bond, what would he like to do about his school situation? And he did state that he would like to either get a GED or something that did not require him to go to Westlake. He did not want to be in a situation where people were asking him anything about his situation. He didn't want to be around that environment at this point. So with Ms. Bond's recommendation that he does virtual academy, which he's already familiar with, if the court granted a bond, I think that would be the best thing to put on his bond. Also, I did explain to him what type of bond conditions the court could put in place, including him living with one of the other parties that I've spoken with and a 24-hour curfew. He was in agreement with all of those, as well as the wearing of an ankle monitor. I did speak with all of the family members that I mentioned previously, including his mother, about that ankle monitor having to be paid for by the family because he is not eligible for the Department of Juvenile Justice ankle monitor. And Javarius he had just received employment prior to arrest in the Camp Creek Marketplace. He had been training at Subway. And so there had been a discussion about him moving to the Cascade Subway to work. But I did explain to him that based on the number of cases that he has and the seriousness of the situation, I don't know if the court would be inclined to allow him to work initially, if at all. And so that he needed to be prepared for the possibility of a 24-hour lockdown in the home of whoever he would be allowed to live with. And he was in agreement with that, Your Honor. That's all the information that I have.
All right. Mr. Petty, do you have any questions of Ms. Singleton?
Thank you, Your Honor. Just one. Good morning, Ms. Singleton.
Good morning.
From Ms. Vaughn, were you able to, did she tell you like who those altercations Mr. Galloway had, about 3 or 4 altercations while at Westlake? Did she tell you who the other involved parties were?
No, she didn't. I didn't ask for the names. I just asked her if she could give me a summary of his discipline. And so she stated over the 4 years, there were 3 or 4 altercations. She was only aware of one during the 12th grade year, and she checked with the office to find out the information so that I would have a correct number. But she did state that they were not considered major events to the school.
Okay, thank you, Ms. Singleton. I don't have any questions, Your Honor. Thank you.
Okay, Ms. Singleton, just to go over a couple of things, and Mr. Hill, you certainly jump in if you feel as though I'm going into an area that is not appropriate as far as you're concerned, but here are my concerns, which you may or may not be able to answer. Number one, he would not set foot on the campus at Westlake, correct?
Correct.
Okay, and I guess first question or second question, obviously, in either one of these homes, would he have appropriate computer connection to do all this virtual?
Yes.
Okay.
In both homes.
Okay. I know we have family members on the call, and so including Ms. Demetrius Galloway, and you know, don't want to put you on the spot. Is there a preference between aunt and grandparents?
Not for me, Your Honor. The difference, there's 24-hour supervision at both. The biggest difference between the 2 homes, of course, would be the age of the care providers and the fact that one would have 3 teenage girls in it and the other, he would be the only younger person.
Okay. Okay. Another issue is, okay, hang on, let's just, this isn't necessarily for you, Ms. Singleton, and this is something that maybe Mr. Petty and Mr. Hill and I can discuss, although don't go, okay? But you would still be able to provide, I know you can't provide the wraparound, but according to my notes from last time, you would still be able to provide some supervision or home visits, is that true?
That's correct, Your Honor. I would do pop-up visits with him at home, as well as I would stay in contact with the private ankle monitoring company. They send me weekly reports via email, and I have phone calls with them. Okay.
Okay. Now, as far from Mr. Hill and Mr. Petty, of course, a huge concern that came up back in August and has kind of remained a concern is contact with other alleged gang members. Is there any update on that, Mr. Petty? I know that you at one point had maybe some jail calls that you had been looking at or were aware of. Any update on that?
No significant update, Your Honor. No, ma'am.
Was one of those with a co-defendant?
Co-defendant, correct.
Okay, and who's that co-defendant's name?
Mr. Baldwin.
Baldwin?
Yes.
Okay. All right.
And Your Honor, I do need to correct one thing.
Sure.
Ms. Demetrius Galloway did point it out to me. The age of her daughters, I said that she had 3 daughters at Banneker. She actually has a 9-year-old, a 6-year-old, and a 16-year-old, 1 daughter at Banneker. And the other 2 are in elementary.
Okay. All right. I'm tempted to ask Mr. Galloway, Javarius Galloway, which one he doesn't prefer, and then do the other one. But I will be very candid. I'm certainly, I'm a little bit more interested at this point in the grandparents. But we're really kind of dumping this all in the lap of granddad at that point. Does anybody want to speak to that? Any of the family or anybody want to go out there with a comment?
Yes, this is Demetrius Galloway.
Yes, ma'am.
I actually wanted to say that my mom is actually not working right now. The school has let them go for a while because of the luncheon situation. So my mother's actually home too as well. She's on my phone on speaker because she had a doctor's appointment.
Okay.
If you need to speak to her as well.
Okay. Ms. Demetrius Galloway, are you of the impression that this is your mom and dad?
It is.
Are you of the impression that they are willing to do this?
Yes, ma'am. She's on speaker on my phone.
Okay. And are they, you know, when I realize my view of grandparents, they're much younger now than I view grandparents, but do you think they're physically and financially up to this?
Yes, ma'am. They are.
Okay. All right. Anybody else have anything to say or any further questions? And I also want everybody to remember there is a bond in this case. It's just a cash bond, I believe, that clearly Mr. Galloway has not been able to make. I don't think he's stayed in because he is an eccentric who just likes to be in custody.
Your Honor, I think that might not be altogether accurate. I don't think that there's a bond on this case, and I will defer to anybody else that has any other information.
Well,
He
that's
does
my
have
understanding as well.
I beg your pardon?
I'm sorry, I didn't mean to cut you off, Mr. Hill.
No, what I was going to say, maybe to augment the court's information, there are bonds in the other two cases.
Okay.
There, and they have, he would not be able to make them as well. But just to be technical about it, there is no bond in this particular matter. In 19 SC 167147, then Your Honor did set a bond. And that might be what Your Honor had in mind when she said that there is a bond. And then in 19 SC, I think it's, I forget exactly what, 168872, that there's a bond in that case, but there is no bond in this case that I am aware of. I don't think that there is one.
Okay, so if I grant a bond in this case, he has to make those other two bonds.
Well, we had requested before, Your Honor, that you would modify all of the bonds, essentially, because he cannot make, he just does not have the wherewithal to make good bonds in those cases. He's been incarcerated for 20 months. Before that, he was in school, and he just does not have the wherewithal to make good bonds. So we were hopeful that we could get it all wrapped up and take care of it.
Are all three cases assigned to me?
Yes, they are.
Okay, so I granted bond on May, and I apologize, you're exactly right. I granted bond on May the 29th, 2019 in 19 SC 167147, and that was the $55,000 good bond.
Yes, ma'am. And
then what's the other case, Mr. Hill?
It's 19 SC 168872.
And is there a bond in that case?
Yeah, there was a bond entered in that case. I think it was on May the 16th.
And how much is that?
I believe it was $27,000.
Okay. Mr. Petty, what is the state's position in regard to these? I don't know if it's linking these matters or because essentially now we've turned this into a modification of the other two cases.
Right. So on the indictment 19 SC 167147, by my count, 2, 3, 4, that is a $55,000 straight bond.
Right.
And then on the 19 SC 168872, there are 3 charges. That's the participation in criminal street gang activity, possession of a firearm or knife during the commission, and then the reckless conduct. Those 3 altogether are 8,500 straight. There are, at least on the booking, other charges that were not presented to the grand jury. So I don't know if those need to be corrected in his booking. So we would not, of course, be asking for a bond. Well, we would not want to include the amounts that are at least that reflect in the booking to be included in his, overall bond, I guess, for lack of better terms. So what I'm, I guess, trying to get at is I believe that with those three charges in the previous indictment, that the bonds as they are reasonable. Taking into account what we've got to do on this case, if your honor is to give him a bond, there are, I believe, 20 counts altogether attributable to Mr. Galloway. I think that the court, I don't, as Mr. Hill once mentioned, a lot of these counts are related. So a lot of the gang counts are for kind of the same activity, aggravated assaults, reckless conduct, things like that. So I would not think it would be my position to max Mr. Galloway out on all of these charges, for lack of a better term. But I do believe that the previous bonds that are set are reasonable. I believe the court has an opportunity here today to set a reasonable bond, given the nature of these charges. So my position would be that, I would oppose a modification to the other two, and that whatever the court deems to be appropriate for this case, I think Your Honor is well aware of kind of what my position would be. I'm sorry. Does that make sense, Judge?
No, it does make sense. I
Okay.
guess I just, Mr. Hill, I guess I'm just concerned that, and maybe I was aware when we heard this back in August, that we've kind of expanded these proceedings to have something that maybe was or was not viewed to be before the court today. In other words, I thought I was just talking about the bond on this case. So I misunderstood. Is that what, I mean, I don't even know if we're in a posture for me to do anything about the other bonds. I just have this case in front of me.
Well, Your Honor, what I would say to that is this: we have spoken about all of the cases together. And so I if they were like discrete incidents that I guess had not been discussed together, then I could see what the court is saying. And if technically, if we need to have another hearing, then I can file, but I don't see the necessity of, I don't think that there's anything that is to be discussed in these other bond cases that if technically I've got to file a motion to reconsider the bond, that would be anything other than making me jump through the hoops, and I'm okay. If that's what we're required to do in order for the court to hear that, then I'm more than happy to do that on behalf of my client. But the last time it was discussed that essentially to kind of have a global resolution of this issue on bond. And what I did state at that point in time was that those other two cases had bond. And therefore the IELA factors and everything that goes into that had actually already been considered. So while I do understand what the court is saying about whether or not technically we could discuss it, I think we've been essentially talking about all of the cases all of the time. There was a lot of discussion about the underlying facts in both of the other cases. So I don't think that there would be anything untoward going on if the court modified the bond. Now, once again, if in order for us to have a discussion about it, I need to file a motion to reconsider, then I'd be happy doing that. But I think that it would just, it would not add anything other than the fact that a motion to reconsider had been pending. Those cases were, I think as Your Honor has noted, they were back in May of 2000. Both of those bond hearing orders were signed back in May of 2019. And
okay.
I just think it would be, I don't think it would meaningfully add anything to the consideration of his bond situation. I'd be happy to do it.
Okay, let me get address sort of the heart of the situation here. And this is something that the state has raised. And obviously, as someone who's responsible for community safety as well as the constitutional rights of each defendant, there are these matters involve guns. He's presumed innocent. There's no question about that. But there are a lot of guns out there. And Mr. Javarius Galloway, if that is your method of solving problems or righting wrongs you feel that have been done to you or others to whom you are owe allegiance, there's really nothing. I mean, I can't, in good faith and good conscience, take this kind of chance. I am willing and have always been willing to take into account your age. And Mr. Hill, I'm relying on you a little bit as to how far I can go in getting an acknowledgement from your client that this is something that he understands, but I need to know that he understands that it cannot, if the court is willing to look at a situation that and my regard for Ms. Singleton and the work she's done on this, I mean, this is over. His relationship with these people and with this kind of problem solving is over. Do you believe your client is at that point?
I do, Your Honor. He's been incarcerated for about 20 months, according to my calculation, or thereabouts. He has actually gone through a lot of adolescent maturation, as far as how old he was there being incarcerated. And I do believe that he understands that there's no benefit to be gained from interacting with the persons that there are some allegation that they were beefing with. I think he understands that. And I don't have a problem with Mr. Galloway indicating to the court that he doesn't intend to try to go out and exact any kind of revenge or to do anything to get into any sort of conflict with anybody else. I mean, I think 20 months, he's been sitting there for 20 months. He's had an opportunity to think about it. And Your Honor mentioned, I was able to observe your previous hearing, and Your Honor hit on a salient point with me. And that was, and I think I brought it up at the previous hearing, and I was trying not to be redundant. But the thing is that for 2 years, that's been his environment. That's been where he's been. He's been incarcerated. And to that end, he has conducted himself in an acceptable manner for 20 months in an environment that is fraught with opportunities to just, no matter who you are, the best of people are going to have difficulty in, being there with people who are incarcerated. They're highly tense situations that you're in. You've got all kinds of people with all kinds of psychological and all other kind of triggers and issues going on, but he hadn't gotten into trouble. The only thing that I was able to do to find out was that he was the quote unquote victim of a situation where they were trying to take his commissary. He is not some person that is just, for lack of a better term, just doubly committed to a course of action where he's just looking to get involved with other people and be in a fight all the time. I don't think that that's the situation with him. I think that what Ms. Singleton said rang familiar with me, and I know the state is going to probably say otherwise, but his teacher, I think, put it in the best, that he basically is a polite and quiet person. And that's the one that I know. I can't tell you, I can't claim that I've been with him every day of his life and what he's done, but that's the Ms. Galloway that I know. You know, he just ain't, and I've been doing this for 40 years, and that ain't the case for all of my clients.
All right, anything further from the state?
Your Honor, no, nothing. Your Honor is well aware of the state's position. You know, we just are concerned primarily with Mr. Galloway's contacts with not only, you know, the opposing parties in all these incidents, but his co-defendants. I'm not convinced just yet that Mr. Galloway, if granted a bond, would have no contact with his co-defendants. As I mentioned while we were last in court on this matter, you know, Mr. Baldwin dialed on to this Zoom, which is not illegal at all. It's his perfect right to do that, but it is evidence to me that they are still in contact with one another, be it friends or otherwise, and that's fine. However, given the serious nature of Mr. Galloway's current circumstance, my expectation on behalf of the state would be that he would stay clear of co-defendants that have brought him into this very situation that he's in. So that's the state's concern. But I don't believe that he's necessarily a bad person. I don't know Mr. Galloway personally at all. He seems to be a polite and quiet young man, which is great. He's just found himself voluntarily in some really bad situations, and on at least 3 instances, decided to discharge a firearm. So we're just concerned with the safety of the community and the safety of the other witnesses, the people who are in back and forth with him and the other members of Bully Block. So nothing that I haven't already stated to judge. If Your Honor is willing to grant him a bond, the state does believe that the conditions we've discussed already previously today and otherwise are appropriate. We do believe ankle monitor, curfew, no association with any gangs, no contact with co-defendants or victims, no firearms or replicas, and no social media. And normally I ask the court for no gang-related social media, but I do believe that in Mr. Galloway's case, no social media whatsoever would be appropriate for the fact that if he's granted a bond, he's able to live with family members. He needs to be focused on getting his schooling completed and being focused on resolving these cases, however we do that, and not placing himself back into the world of social media, which will just eventually draw him back into contact with co-defendants and the like. So that would be the state's request.
All right, y'all give me just one. I know you've been waiting patiently, but give me just one moment.
Sure, Your Honor. Thank you.
All right, Samantha, we ready to resume the record? And I'm going to assume that we are. I don't need to restate the obvious for everybody, which this is an excruciatingly hard decision. It's hard because hold on one second. She hasn't texted back yet. So. Okay. I don't want you to go and then. We're just confirming that, okay, all right. Back on the record, I don't need to restate the obvious for everybody. This is an excruciatingly hard decision because there's no room for error. Mr. Galloway is absolutely presumed innocent. This is a different world that he would be going back into from the world he left 20 months ago. Guns are everywhere. And it would not even be challenging for him to either fall right back into that or get involved in some way that would be too challenging for our community.
Yeah.
Hang on.
No. Your Honor.
Hang on.
Okay.
And if I end up trying to explain to a family that I was unwilling to throw Mr. Galloway away, then that is what the people of this county hired me to do. Accordingly, I am going to grant a bond with the following conditions. Mr. Galloway, at his own expense, will have an ankle monitor, which will be on and accessible at all times. It will be up to him, not the county, not anybody else. He's 19 now. It will be up to him to make sure he is wearing it at all times, that it is adequately charged at all times, that it is paid for at all times, that he remains subject to monitoring at all times. He is to live with his grandparents. We will get that address, if it's okay with you, offline. He will live with his grandparents, who I believe are Mr. and Mrs. Williams. Is that?
Yes, Your Honor. Miss Aura Williams and Mr. Cleotha Williams.
All right. Now, I want to, and I'm going to give a lot more conditions, but I want to also tell you that with me, you get exactly what you earn. So these conditions are going to be as harsh as possible to begin with. And then provided that Mr. Galloway makes the progress that I expect, then we can revisit them. But for right now, he is on 24-hour curfew, period. Now, he can go out for medical. I think Mr. Hill said something about haircuts. Somebody can come cut his hair. Medical at this point would be the only exception. Not even legal. You can talk to him on the telephone, Mr. Hill. He will have supervision as suggested by Ms. Singleton. And Ms. Singleton, I want to put that in the conditions of the bond. And if you need to explain any further to Mr. Galloway or his family exactly what that entails, you can either do so now or you can talk to them later, but he will have supervision by you, correct?
Yes, Your Honor, and I'll discuss the details of that with the family after his release.
All right. Now, I want to talk about the environment in which you are going to be required to live, Mr. Javarius Galloway. I'm not going to cut off all computer contact because, of course, that's going to be the part of this, is that you must attend virtual school and that you must pursue your high school degree. So obviously you're going to have access to a computer, but you are not to own a cell phone. No cell phone. You are not to have any social media. This is essentially, this should be something, unfortunately, that you're accustomed to. But you are not to have any social media whatsoever. And if there is any, and believe me, I'm sure the state will be looking for it. If there is any activity that suggests that you've either been on social media, participating in any way, shape, or form, that you own a cell phone, or that any cell phone number is associated with you, you are going to go right, that will be a violation of your bond, and you're to go right back in. And then we'll try your case when we can get to it. You are had to have no contact, absolutely no contact. They can't come to your grandparents' front yard and look at you through the window. You are to have no contact whatsoever. I cannot be clearer about this with any of your co-defendants, with any known gang members. And Mr. Petty, which one is he in, allegedly?
Bully Block, BULLYBLOCK.
You may think they're your family, you may think they're your friends, but they're not now. Because if you have any association with them whatsoever, you're going right back in. They won't be held responsible. You will be held responsible, and you will be right back in. You are to have no association whatsoever with any gang members, no social media, no firearms. Mr. Galloway, if you so much as think about a firearm, I'm being somewhat facetious there, but there are no guns in your future, none. You were to have absolutely positively no contact with any victims. And you're just going to stay at home for the next several, however long, with that ankle monitor on, logging onto the computer and learning as much as you can. Now, insofar as amounts are concerned, I'm going to assign amounts for each of these counts in 19 SC 171071. There are, Kathy, how many are there? 070. What did I say? 19 SC 171070. How many counts are there?
Ron, I believe Mr. Galloway has 20 counts. There's 24 on the indictment, but there are 20 that pertain to him.
All right, that's $10,000 per count. And that will be through the pretrial program. Now, does putting him through the pretrial program doesn't take him away from you, does it, Ms. Singleton?
No, Your Honor, I am pretrial.
Thank you. Thank you for clarifying that for me. And he will report then to Ms. Singleton, correct? Or does he need?
Yes, Your Honor. All cases that you place under pretrial, he will be with me.
Okay, so that would be. Can we agree that's highest level of reporting?
There is actually no level because my visits are all pop up and random.
Okay.
So he will get that under the supervision. So the bond orders will all need to state that he's to be released to he's coming out of the jail. So you don't even have to put a release name on there, just put supervised by me.
Okay. Now we'll get to all cases in just one moment.
I'm sorry, Your Honor, yes.
I've been asked to repeat the indictment number in this case because I said it wrong the first time. 19 SC 171070. Mr. Petty, and I want to say for the record and for anyone listening, and I was 100% stand behind my statement, this is very much over the objection of the state. I will ask, Mr. Petty, are there any conditions that I didn't say correctly or that you would add?
Your Honor, I don't know if it was today, but maybe previously I might have asked for stay away from the incident locations. I don't see that. I don't know if the court wants to make that a condition, seeing as though he's under the curfew. But otherwise, I believe Your Honor has addressed them all.
Okay. Now, I don't know what to do about the other bonds. I really don't. I know Mr. Hill wants a global bond here. If I can, I don't know how to do that. Mr. Petty?
If Adam agrees, if the state agrees, you can do it.
Well, I'm not even going to ask him. I mean, those bonds were entered after individual consideration of those cases. And I realize it's ridiculous to try to come up with a solution that doesn't include those. But I'm really just looking for some guidance here. I don't know that I can just tie all of these together. Mr. Petty, do you?
I don't know that you can either, Judge. However, I mean, the state, I understand the court's intent, which is presumably to have Mr. Galloway make a bond that allows him to be living with his grandparents under those special conditions. I understand that, as Mr. Hill already mentioned, if he's unable to make the bond on the other two cases, I don't believe it necessary for Mr. Hill to have to file for a modification. The only caveat that I have is I have not had contact with the other victims in the other two cases. So I would like an opportunity to, I guess, to just kind of let them know if the court is going to make any modifications on those bonds. But other than that, I believe that the court's intent is clear, Your Honor.
Well, how should we leave that? Can I give you to the end of the week to, is this one of those things where he can only get out one particular day of the week, or is that only at Metro?
That's only at Metro, Your Honor.
Your Honor, if I may interject right now. When I said global, I wasn't intending to say that we do anything that, let's say, we normally don't do. I'm just saying that we can talk about address those individual cases. And for instance, in 19 SC 167147, I'm just saying that if we could give him pretrial supervision, the same conditions, same amounts, but instead of it being good bond, just make it pretrial supervision the same way. So global resolution just had to do with the fact that we were addressing them today.
Well, I think Mr. Petty's point about notifying those victims, those are different victims in each of those cases.
They are, Your Honor.
I think his comment about that, though, because those people could have attended this hearing.
I understand that. I was really addressing only how, taking care of that, and I understand that popped up as an issue. But as far as actually the structure by which we could address it, it would in fact be a modification of the bond to coincide with very similar conditions, or if not the same conditions.
Well, what about this? Would Mr. Javarius Galloway, and I don't want to make this a condition, but if we could get the other two matters on a calendar as quickly as possible, giving Mr. Petty an opportunity to notify those victims, would you discuss with your client, Mr. Hill, the possibility of waiving his appearance?
Yes, You want to break us out now?
Huh?
Would you want to break us out now or when? When would you?
No, when could we?
Well, I mean, I can't add it onto another Zoom. Next one's full. But we can do it any Tuesday or
do it next
or
Tuesday.
Thursday. Yeah. Let's do it next Tuesday.
We could set these other two matters down for next Tuesday. And if he and he doesn't have to, but if he were willing to waive his appearance, that would give Mr. Petty an opportunity to reach out to those victims. One of those cases, I think I gave a bond because it was past the 90 days and I had to. Isn't that, Mr. Petty? Do you remember that? That was on.
That might have been the.
That was 19 SC
872.
167147.
No, that Yana is correct about one of the bonds was granted because it was past the 90 days, but the armed robbery case, which is 19 SC 167147, was it was indicted and it was after Yana just had a regular bond hearing.
Okay.
But it was not the
Judge Ashley granted bond in the case that had not been indicted.
That's correct. That's in 19 SC 168872.
Okay.
Correct.
Okay. Let's do that then. Let's put those, we'll get this one drafted, we'll get it entered, and then we'll put the other two on. Mr. Petty, can you be here next Tuesday?
I will be traveling. However, I can either myself or someone else from my unit can certainly be on Tuesday, Your Honor.
Okay.
Your Honor, we've got Miss White on the line. I don't know if she can hear us. I don't know if she's had any contact with the victims on the other cases. That she may have spoken to them more recently than I have, and may have some information that could be helpful.
Ms. White?
Yes, I spoke with the parents of each of the victims. One of them didn't want to show their faces. Two of them opposed bond, and one of them was okay with bond, but they didn't want to appear.
Are those on other cases or on this one?
On this one.
Okay, let's set the other two then for next Tuesday. Mr. Hill, can you be present at that?
I will make myself available. Yes.
All right, we'll send out a notice, and Mr. Petty, you can let everybody know. Is that acceptable?
Absolutely, Judge. Thank you.
Okay. Now, Mr. Javarius Galloway, Mr. and Ms. Williams, or at least Ms. Williams, and the entire Galloway family, I want you to understand that there's no margin for error. There's no, I'm sorry, I didn't understand that. There's no, well, I'm at the Kroger and I ran into some old buddies. That's not an excuse me. That's not, I didn't understand. There is no margin for error. He is to be in that house with his grandparents. And if that is not acceptable, then he can stay right where he is. But I cannot be more serious, Mr. Galloway. Do you understand me? Do you understand me, sir?
Yes, ma'am. Yes, Your Honor.
You understand?
Yes, Your Honor.
Okay. All right. Then I will see everyone else next Tuesday and we'll go from there. Yes.
Ma'am, is it possible to break me out to speak with him? Sometimes I have difficulty getting in contact with Mr. Galloway. Could you put me in a breakout room with him?
Kathy?
I can show you.
She did, and it would be very brief.
He's in
Courtroom 2.
Yeah, where is that? Did they already take him out?
No, he's showing visually on the screen.
Okay. Let me close all the rooms and start another one. Okay. So open all the rooms. Did you get one on that one?
Yes, ma'am, I got one.
Okay. So you guys should be able to break out now. Okay.
I think they're in the
Okay. Thank you. So I guess you can just leave.
Okay.
it open and they can close their-
Can we go off the record for just a minute, Samantha? Ms. Singleton, how are you?
I'm good, Your Honor.
You keeping safe and well?
I am. Thank you for asking.
Good. And Ms. White, how are you? All right, I'm going to assume you're fine. And
Doing great.
good. We miss seeing you, Ms. White. I haven't seen a mustard colored blazer in a long, long time.
Oh, the blazer.
Okay.
Excuse me, Your Honor.
Ma'am?
I know we're off the record. My mom wants to know when we go back on the record if she could speak.
Okay.
Okay, thank you.
Do I have a civil hearing?
At 1. Did you have one this morning too? Just.
Your Honor, can you hear me? I can't hear you. You're muted.
Yes. Yes, sir.
Okay. I just spoke with Mr. Galloway, and he said it was okay that we could proceed without him being present.
Okay. All right. And if we could go back on the record for just a minute, Ms. Demetrius Galloway has asked whether Mr. Galloway's mother could speak. And Mr. Hill, I guess that's a question for you. I'm
No,
fine.
I'm sorry, Judge. It's his grandmother and myself.
Mr. Hill, that okay with you? Okay.
Yes. That's
All right. Is this Ms. Williams?
Yes, can you hear me?
Yes, ma'am.
Oh, how you doing?
Fine, thank you, ma'am. I hope you're fine.
Well, I just want to thank you for all the work you're doing for him, and I just want to let you know that, hey, I'm ready for him to be with me. Me and my husband are ready for him to be with us. And we know the rules and everything. You don't know. We very strict. So you don't have to worry about that.
Okay. Okay. That's a deal. Thank you.
You're welcome, ma'am.
All right. Well, if there's nothing else, then I'll see the lawyers next Tuesday and anyone who wants to appear at that. And I appreciate everybody's patience today. We had some technical glitches and then I filled in quickly for a judge who's ill. And so I do appreciate everybody's patience. Particularly, I'd like to thank the Rice Street personnel. This does not happen without their participation. And I, for one, am very grateful. Plus, we've gone late today. So if there's nothing else, we'll sign off and let everybody go on about their day.
Your Honor?
Yes?
This is Demetrius Galloway again.
Yes,
I had a quick question about the conversation that was held prior about him actually being able to reoffend or run into a victim or a co-defendant. If he's on 24-hour lockdown in my parents' house, how is that supposed to actually occur?
This is what we call belt and suspenders. You don't need both, but it doesn't hurt. We're going to put all the language in this bond that we can to make sure that Mr. Galloway understands that his relationship with those individuals is over.
He knows, but okay.
He knows, but okay. Okay. Thanks, everybody.
Thank you.